What's up, everybody? Welcome back to yet another reading of a letter from Sarah Boone. And this is the first letter we're going to read since she started representing herself, but she did not write this letter as her own lawyer. We're going to take a look at the docket, look at the timeline of how this happened, and what an epic failure this must feel like after what the judge ruled when she turned in this letter in court, and where we think this case is going from here. We're also going to take a look at some interesting things Florida does to try to help pro se litigants in situations like Sarah Boone's. And of course, we will answer your questions as always. So hit that like button, subscribe to our page if you have not already, and let's get into it. So the first thing we're going to do real quick is just look up the docket for Sarah Boone to see where we're at. We're going to look at this again after, but if we look down, you see this correspondence that's 58 pages that was given to the court on June 21st. Then on June 28th, the court had this hearing on the motion to withdraw. He entered his order, which we read on the last video in its entirety. I think it's a 16-page order. Yeah. Granting the motion to withdraw, finding that Sarah Boone forfeited her right to counsel. The interesting thing is, this 5-page letter that we're going to read was given to the court on 6/28. So on June 28th, when they had that hearing and when he decided that she forfeited her right. So that means she wrote this letter on June 25th and gave it to the court, thinking potentially that she was going to convince him to be on her side with Miss Cashman and either force Miss Cashman to do what Sarah wanted her to do, or give her another lawyer potentially. So it's very clear the tone of this letter is not somebody who feels like they've lost. It's not what they want. They're not going to get their way for the first time in a while, because she's been asking for new lawyer after new lawyer, delay after delay, and she's been getting her way with that so far. Your Honor, it was made known to me by an officer here at the Orange County Corrections Department that my attorney, Patricia A. Cashman, has submitted her motion to withdraw on 6/11/24, which now explains why she has not contacted me nor answered calls. Yeah, well, it also happened because you walked out of meetings and wouldn't talk to her and didn't treat her with respect. So this is kind of what happens in these situations, and Sarah Boone seems somewhat surprised. Why hasn't anyone sent me a copy so I know? To confirm, my exclusion in my case, especially by Attorney Cashman, and stated in all of my letters previously written, I was not included and am finding out weeks later. This is 2 weeks after June 11th. Judge Kranick, I am trying to receive, please, a copy of her withdrawal to better understand her reasons for the undisclosed departure from my case. So she's acting as if she doesn't know what the issue is. And if we look back at the docket, which I'm looking at it, but you don't necessarily have to, they met and talked about this case in a hearing that we all watched, where Miss Cashman made very clear her issues with Sarah Boone. She put her reasons for withdrawal right out there for Sarah Boone to hear. Sarah Boone called her a liar. Sarah Boone accused her of a bunch of different things. And now Sarah Boone is acting like she does not know why Attorney Cashman would ever want to withdraw. Debbie asked, are you going to her trial? Yes. I'm not going to go every day. Obviously, I'm not able to do that. I think they said it was going to be 4 or 5 days. I'll tell you, when I was a very young prosecutor, I tried a case in Florida, not in Orange County, but in Pinellas County, against a pro se defendant. This trial should have been a half day to a day max. It was a simple misdemeanor. It wasn't simple. It was kind of a complex misdemeanor, if such a thing exists. And it took us all of 2 days, starting early, staying late. More realistically, on the trial calendars that we've been watching, it would have taken 3 days for something that should have taken a half day to 1 day. If you look at Darrell Brooks as our next example, you see how much longer these trials can take than they should because you have a pro se litigant not knowing what they're doing, asking maybe inadmissible questions, needing some extra explanation by the judge to understand what's going on in the process. And again, we're going to discuss some things and some resources Sarah Boone has at her disposal to figure this out and be ready when it is her time to show up under the bright lights, when it comes her time for trial. Yobi, by the way, I've been getting a bunch of packages from you with all sorts of golf goodies, showering me with presents for 400,000 subscribers celebration. So thank you for that. Yobi said she watched the Karen Reed trial and thought she would get a Yannetti or Jackson for free. You should represent her. At least it's free advertisement, not the type of advertisement I'm looking for. And that's the great thing about being a private attorney. I get to fight for causes and people I believe in. Sometimes there are issues and sometimes relationships are strained and we don't always see eye to eye, and that happens. I'm not saying it doesn't, but this is something I do not want to get into, and thank God I don't have to. Peter, did you see Proctor has to give up his gun and badge? I did not see that, Gigi. Feel free to tag me on Twitter and Instagram. If you guys see posts like this, I'll check them out. Dana, Peter, what happens if Sarah absolutely refuses to represent herself? I can see her refusing. The court can give her instruction, give her warnings, similar to what we saw on Daryl Brooks. But if she wants to sit there silently, that is also her decision, and she would be effectively waiving her right to represent herself or ask questions or cross-examine. And again, that's something that'll be picked up on appeal. You don't want to take your chances on appeal because appeals are for losers and you have to lose first. The percentage of appeals that you win are very slim. And again, she's not going to have private counsel for that appeal. So not the best course of action, but if she wants to be as difficult as possible, I could see that happening. All right. Page 2. No attempt was made on her part to solve or remedy in some type of discussion professionally beforehand. Therefore, I am having to include you for this request as I did with my most recent letter. So again, look at the tone. She's like, she's trying to withdraw, judge. She wouldn't even implement anything to try to work this out, like my pretend judge and those things that I feel like should work, but she's not letting me. So now Sarah Boone is reaching out to the judge for help, to the judge to try and force her, force the judge, or have the judge force Miss Cashman to do what Sarah Boone wants. Give her her way. Please understand, I am trying to understand. With her attempted withdrawal, and again, attempted withdrawal, which she has seen before, if you want to rewind back and look at some of the other videos, when lawyers have tried to withdraw and Sarah Boone says, no, I want them to continue to be my lawyer, usually the judge says, okay, let's try this again. And then when Sarah Boone says enough is enough, the judge gets rid of the lawyer. And that's the way the law is written. We want to protect these defendants. We want them to be represented by counsel. We don't want them hanging out there left to dry. So that's why it's happened. And it seems like she's confident that's what's happening again, that she is in control. My very legitimate concern now is not having all my case contents returned to me. As with most of the prior attorneys to date, many of my evidentiary case items cannot be located after my numerous requests to the attorney on my case and that time, and to Attorney Cashman at that time, to her prior attorneys. No one knows where my case items are, who has what, or cases to research and return now that I am no longer under their representation. Shrugged shoulders, avoidance, and lies of where anything may be is all I have received when requesting from former unwilling, disingenuous attorneys. These are my case documents. Attorney Cashman stated to me more than once, from me asking repeatedly about that she had reviewed all of my discovery, which I was withheld from reviewing also. So I do not even know all she had specifically and completely and what was available to me. Well, Sarah Boone, you're about to find out. Because as a condition of granting Ms. Cashman's withdrawal, the court said she has to return all of Sarah Boone's case items, discovery documents to Sarah Boone. And My guess is Sarah Boone's going to say, I know this exists, or another lawyer told me this exists and I don't have it. I have a feeling that's coming. What I'm really, so we've got a lot of letters, there are a lot of eye rolls in these letters, but oh boy, am I looking forward to the next letter. Because again, she gave this to the judge before she knew she was going to be forced to represent herself pro se. Yobi, is it possible she was blacked out in the videos? I think it's possible, but we'll see how that argument comes into play with Sarah Boone, who says she was not drunk. And maybe the lawyers were like, listen, Sarah, that's going to be a tough argument. But we saw the interrogation video, and that's kind of the story she went with. Michelle, is it legal for the judge to read her letter? So if this was an attorney letter, an attorney-client privilege discussion or communication, then no. But she's writing it to the judge. She's making this public. She knows this goes as part of the public record and is therefore not confidential and not privileged. She knows that at this point. This is a willful waiver. She thinks she has the system down. Well, Victor, we're going to find out if she's got the system down, right? Because she's going to be playing lawyer. I really can't believe we've gotten here. A lot of you called it. Anita, hi, Peter. I just watched the interrogation of Sarah on your channel 1 year ago. You were wearing headphones, and I like you with a beard too. Thanks for all you do. Thank you, Anita. Yeah, it's funny. It's cool how these, we do these videos, and unlike a presentation or a conference or something like that where they may go away, YouTube is a great thing where they just sit there, and anybody that's new to a case or that wants to go back and watch again or wants to remember what we said or clip something out. I've seen some accusations potentially thrown around on Twitter and other people clipping what I actually said, which is always fun and interesting. And I stand by my comments for the most part. If I make a mistake, I'm the first one to put my hand up and say, hey, I screwed up, made a mistake. But it's very cool to have all that documented. Joanne, oh, the consequences she is now facing. Can these letters be used as evidence to show how bat crap crazy she is? Only if they're relevant. So a lot of them are not relevant. If she starts to put in here certain facts or accusations or admissions, then yes, they could absolutely be used against her at trial. But it's got to be relevant. It can't just be to make her look bad. Mary, I think you were reaching 200,000 when you were going to go to this trial. Now here we are at 400. It will reach 500 before or if it ever happens. Yes, this was the 200,000 subscriber kind of celebration, whatever you want to call it, thing people requested is that I actually go sit in a trial, look at the jury, and see how it's going to work. And Sarah Boone was the one we picked. We thought it was actually going to go 200,000 subscribers ago, and it still has not happened. So we are waiting. If it actually goes in October, that's a pretty good chance that I end up there. I think I do have a trial in October, which would make this impossible if it's the same week. But if not, then we're going to do it. We're going to do it. All right. Let's keep reading. Your Honor, how can I ensure, please, the return of all of my case contents from Attorney Cashman? When may I finally review my discovery and the contents she has of my case so I know what is still missing or lost? Exactly. We know that's coming. Also, Cashman was like, yeah, she said she never saw these medical records, yet they have her writing on them. So where's the truth? Pardon me for having to utilize your invaluable time to ask to receive my invaluable case items. Now, is that sarcastic? I don't know. But again, whether it's sarcasm, whether it's a guilt trip, it fails miserably when she gets the answer from the court as she hands him this letter. I am trying to understand how and when, please understand, I'm trying to understand how and when I can finally rightfully defend myself. Due process is due, overdue. I thank you in advance for my inclusion to also receive a copy of Attorney Cashman's withdrawal notice and for helping in the ensuring of all my case contents be returned successfully for my historical review from Cashman. All other former attorneys also, please, if possible. Judge Kranick, you will never understand my gratitude for listening to me, giving me the opportunity to finally be heard, and your apparent caring judicial manner. Thank you immeasurably. This is her buttering him up, in my opinion, because she did the same thing to some other judge. Then she would throw strays at them, absolutely take shots, whatever suits her. But at this point, she's trying to catch flies with honey. Thank you immeasurably. I await the next appropriate step in moving forward, however and with whomever. Well, the with whomever is going to be answered for her very quickly as she turns in this letter. And then at the end, she says, for inclusion futuristically and to ensure receipt of all correspondence to me in my case, my address is as follows. I don't think that's the problem, Ms. Boone. I think everybody knows where you're at. I think everybody knows where you're at precisely. I am also including attorney Patricia A. Cashman with a copy of my letter, mailing it to her address. And there you have it. The most recent letter from Sarah Boone. Let's take another look now at the docket. First off, in that same court date, you guys might not be able to read it because it's small, but I'm going to read it. Per the court comments, the court made findings that just imagine, okay, we read that letter. That's Sarah Boone's mind frame. She's walking in thinking, I'm going to have him force Cashman to do stuff. I'm going to force her to keep being my lawyer. I'm going to butter this judge up because I'm so manipulative and I can get people to do what I want. Well, here's what the court found. The defendant has forfeited her right to counsel. The motion to withdraw is granted. Cashman gets what she wants, not Sarah Boone. As a condition of attorney Cashman's withdrawal, she shall provide the court an order for costs and obtaining transcripts of depositions for the two witnesses she deposed. I mean, she did a lot of work and not a lot of time. Upon completion of the transcripts and the depositions, the deposition transcripts shall be sent to the defendant at the Orange County Jail. Attorney Cashman shall file her notice with the court reflecting that all deposition transcripts were provided to the defendant. All previously set dates remain, which is important. All pretrial motions must be filed no later than close of business on July 22nd. That is 19 days for Sarah Boone to file all pretrial motions, motions in limine, expert, Daubert motions, motions, to exclude certain witnesses, motions for affirmative defenses if she's going to use one. All of the pretrial motions must be filed in 19 days from today. None have been filed as this is the docket and we don't see anything new filed, but the court ordered attorney Cashman to provide the 2 boxes of discovery with the clerk marked as identification A and B. The court will reach out to the jail to inquire how to deliver to the defendant. So this is interesting. This indicates to me that Cashman brought Sarah Boone's discovery, showed the court, this is all I have. It's 2 boxes. This is all that was given to me, and give it to her because I have a feeling accusations are coming from Sarah Boone. I just have a feeling. And then we see the court minutes again on June 28th. The defendant was placed under oath. Court read on the record its order as it relates to the motion to withdraw on the defendant in open court. The defendant gave a statement and asked questions of the court and of his order. The defendant was provided a copy of the court's order hand delivered on 6/28. So has anybody seen this hearing? Because I have not. I'm pulling something up here. If you guys have seen it, send it to me and we will take a look at it. Daybreak. All her lies about her lawyers only make me doubt past claims about George's abuse of her. All right, so this is on Court TV. Let's see if this is the hearing. Title is Judge Rules Sarah Boone has to represent herself. I don't know if this is the actual hearing or not. I haven't watched it. I haven't seen it. Let's take a listen here real quick.
Hearing held on Friday, the judge granted Boone's former attorney's motion to withdraw and ruled that the defendant has forfeited at this point her right to counsel because of her ongoing difficulties with past attorneys. She will now have to on October
to let everyone know who I really am as opposed to the malicious murderer that everyone thinks that I am.
This is from the prior hearing. So yeah, I saw stuff like this. But I have not seen this actual motion hearing. I would love to see it because she asks questions about that motion to withdraw that was granted and the court's order. So I can't wait to see that. All right, before we get to the last thing I want to read, a couple questions. Katie, I got summons for jury duty next month. I do have a bad back, and with me loving trials, am I someone a lawyer would choose? Bad back, they will give you as many breaks standing, let you bring a pillow to sit on or to lean back against. They'll let you be as comfortable as possible. So you just let them know about that. Unless you think the bad back won't let you do it. If you tell them that, they'll let you go as a hardship. But if you tell them you're going to come fair and impartial, that you've watched trials before, you feel like you understand the system, but you're not going to come in thinking it's just one way or the other. You understand reasonable doubt if it's a criminal case or burdens of proof or whatever. You could be really great. You could be really great potentially. Depends on the type of case and what your experiences and backgrounds are as well. A+ for speed reading skills, Peter. Christy, I got a lot of practice. Uncivil Law says, I should represent her. I can fix her. Would not wish that on you. I would not wish that on you. Twixie Shores, are the deadlines that serious? After all, Sarah got straight A's and excels at everything. The court made it seem like in his order, he did not want to continue this case again. But like I said, if there's a legitimate reason and Sarah Boone is like, listen, I want to talk to this expert. I want to prepare him. I have a couple witnesses I want to call. I got to figure out how to do all this, Judge. I need more time. My guess is the judge will give her more time in, of course, the interest of justice, right? And to make it a fair trial. He's not trying to screw her or anything like that. So let's take a look at this real quick. I found this to be interesting, and maybe you guys will too. So this is from the 12th Judicial Circuit. So this is Sarasota. It's not Orlando, but different jurisdictions have different situations. And this one is specifically for a civil case. But I think it's cool that they do stuff like this. And on civil rules, we try to put in the rules and statutes language and forms and things that if somebody's going to represent themselves, which happens a lot in, landlord tenant or bankruptcy sometimes, or family law, not as often in criminal law, but things that can help litigants go pro se. Okay. So things you need to know before filing legal papers. You need to know about the court staff and the employees, and they can't give you legal advice or help you with forms. Please don't ask them. When you act as your own lawyer, you're held to the same standards as an attorney. It's your responsibility to select the right forms and properly complete them. If you need help completing the forms, you may ask help for friends or visit a lawyer or hire a paralegal. Pretty interesting, right? That they actually tell people to do that. If you believe you've selected the correct papers, file them with the clerk of court. However, if you've chosen the wrong papers or they're incomplete, your case can be dismissed or delayed. Take time to do it right. No action will be taken on your case until the correct papers are provided. The law requires certain petitions and motions to be served on the opposing party by use of a process server. Failure to do so may prevent your case from moving forward. You must determine when personal service of a paper is required. And again, we try to put this stuff in the rules. All motions and many other legal documents must contain a certificate of service showing copies sent to the opposing party. If you are defending a case, failure to file the correct response may result in a default, which means you lose. Court staff screen all out-of-court communication between you and the judge. Judges may not see your letters, notes, emails, or phone messages if they do not meet the legal standards or if they contain inappropriate information. Again, a little different in criminal court. Make sure you can live with the consequences of litigation. If you're starting a proceeding, be aware opposing side may respond by asking the court to take action you do not like. Failure to appear in court can have negative results. Your case is an open book with few exceptions. Florida is public record. People will know what you file. They will see this. There are no warranties given as to forms. What you need to know about the proceedings: carefully read the rules. Do not bring your children. The court always prefers both parties to attend. Always read or listen to the instructions. Wait outside until the bailiff tells you to come in. If you're told to bring your driver's license, bring it. If the judge should interrupt you, stop talking and listen. Darrell Brooks could have used this, right? Do not interrupt the judge or the party or witness. Speak directly to the judge. Stay focused on the issues. Be prepared. Some lawyers could use this. Status conferences. These are short hearings before the judge, magistrate so that the court can identify any additional documents that need to be filed, identify any conflicts, possibly refer to the litigants to mediation to attempt to resolve the issue, set a final hearing, or trial date. Speaking of final hearings and trials, what is a hearing or trial? That's what you meet with the court and both parties. The court will consider evidence and both sides will present and make a decision. Could be before a jury, like in her situation. The court cannot investigate the case. How much time will you have? Again, just generally talking about the trial, presenting your case, prepare an opening statement. What are we here for? Has an agreement been reached? How many witnesses are you going to call? You can submit evidence. You can direct witnesses, cross witnesses. All documents or items you present to the judge and questions you ask of the witnesses must be relevant to the issues before the court and the facts you need to prove. You can testify as your own witness. You can call other individuals or witnesses, and you can subpoena witnesses. They go through the objections. Okay. They literally list objections that you can use in trying your own case. Something's ambiguous, that it's argumentative. Counsel's question is really argument. Excessive quibbling with the witness. Asked and answered. Assumes facts not in evidence. Authentication is lacking. Best evidence rule. The original document must be offered. Beyond the scope. Compound question. Asking for a conclusion. Confusing and unintelligible. Counsel is testifying. It's cumulative. It's lacking foundation. It's improper impeachment. Improper characterization. It is irrelevant. It is leading. And the form of the question tends to suggest the answer. Counsel's question misstates prior testimony of a witness. It's a narrative. Question is broad or covers such a large period that it would allow the witness to ramble and preserve hearsay or irrelevant evidence. Opinion. Lay opinion, which is beyond the scope permitted by the Florida statute. So an expert can testify to their opinion, but lay witnesses cannot. The prejudice is outweighed by the probative value. Probative value, meaning what does it tend to prove or disprove, is far outweighed by the prejudicial effect of the evidence. It is privileged. Speculation and conjecture. Question allows the witness who lacks personal knowledge to guess. Unresponsive. The answer includes testimony that was not called for by the question. Hearsay is a legal term for any statement, verbal or nonverbal, offered as evidence that is not based on a witness's personal knowledge, but instead on another person's statement that was not made under oath. Generally, hearsay is not admissible evidence. Of course, there are a million exceptions, which they did not put in here. I think I hit and read the definition of all the ones you guys have had questions about. Let me scan through here again. Unfair to allow counsel to emphasize evidence through repetition. That's asked and answered. Yeah, if you guys have any you want me to read the definition that I didn't read, that I just read the title of, let me know, and I can. Uncivil really wants this. He says, just call me the Sarah Boone Whisperer. Brooklyn Basement thinks she'll fare better or worse than Brooks. Better. I think she will fare better than Brooks, if I had to guess. Yobi, could Daryl Brooks represent her on Zoom? No. Thank God for all of us. Tina, Peter, how much money can she have for experts, etc.? I don't remember what the decision ended up being by the committee but they did give her some funds for court-appointed experts. I don't know if she's going to use them. We've kind of lost some of the discussion points that we had on with some of the lawyers about wanting certain experts for certain defenses like the battered spouse syndrome and things like that. So I'm not sure where we ever got, but I know that she has allowed some amount of money for experts. Will she use it? Will she know how to use experts, question experts, deal with their reports, cross-examine the state's experts? I don't know. Christy, as pro se, will Sarah Boone get extra free access in jail to computer time and supplies for free to help her prepare? I think she has enough access to that as it is. If she needs it to prepare for trial, yes, the court will usually make sure that happens. Linda, do all murder cases have to be before a jury, or can Sarah ask for a bench trial since she's representing herself? She and the state would have to agree to a bench trial. Usually if the defendant asks for it, the state, barring some unforeseen circumstances, is usually okay with it. Sometimes they're not. But the vast majority go before a jury. Okay. It talks about getting interpreters, obtaining your final judgment, and doing research. Because you're representing yourself, it's your responsibility to become familiar with the rules and the laws. So do we think Sarah Boone is going to come to a situation where she starts feeling like the judge should tell her what to do, or the clerk, or the state, or some other lawyer should tell her what to do? Because I foresee her complaining that this is unfair because she doesn't know what she's doing. She's not a lawyer and the state has a lawyer. And the judge in front of the jury is probably going to tell her to chill, but he's not going to say in front of the jury, you forfeited that right because how you treated all your other lawyers. That would be prejudicial. That would create a mistrial situation. So I don't foresee that happening, but I do foresee her complaining and saying that that this is unfair, that this is not due process, that this is not constitutionally proper because she is being treated unfairly and her rights are being trampled on. New Hampshire said, what kind of experts would she hire? I see this as a situation where there are two kinds of experts that could help with this. Some kind of alcohol expert, how it affects you, how it affects your decision making, even after, or mental health experts. Why would she lie? Why would she not know if she blacked out and didn't remember? Or if it is a battered spouse syndrome and the way that he treated her or battered her in the past, allegedly, could be a situation where she did not want to let him out of the suitcase because she was afraid of how he would respond based on his actions and prior interactions with her, where he responded negatively. He physically abused her, and that's why she was too scared to let him out, and then she passed out. I don't know that to be the case, but some kind of mental health expert potentially that could testify to things like that, that would make her fit into the battered spouse syndrome defense. Beverly, this has passed the point of justice and become absurd. The cost of her nonsense is borne by the people of Orange County. When are their rights considered? Well, sounds like the judge has considered their rights. By the way, Bev, on our 4-person Zoom call, Bev asked for an update on the Lori Vallow case over in Arizona. We are going to do a short on that. And if you guys are interested in more digging in deeper, go to the short, comment, like it. Let me know that you want me to do a deeper breakdown on what's going on in that case, because there are some continuances, some speedy trial issues, and some cameras in the courtroom issues. Question, where do inmates keep their boxes of discovery? So different jails have different places for them to keep them. Some keep them in their cell with them. Did you say there were only 2 boxes of discovery to go through? It sounded like the court was only telling Cashman to turn over 2 boxes of discovery. So that could include hard drives or flash drives or thumb drives or disks. That could include things that have more documents on them. Most of my cases till I go to trial have 0 boxes worth of discovery because it's all digital. Who was the pretend judge? So she tried to create a situation with Cashman because she said it wasn't going well and Cashman was not treating her appropriately or respectfully enough, that she said, let's have a pretend judge, where if we have an issue, what would a pretend judge say? Talk about being condescending and just brutal to a lawyer. Lynn, is it a thing to increase pretrial time to get more credit on sentencing? So not really, especially when you're looking at a sentence as long as she could potentially be looking at, which is life. But if you think it's going to help your case for a lawyer to really prepare, and you think you might be found guilty of a lesser included and maybe take a plea deal, then you don't really care if you're sitting in jail, right? Doesn't seem like she's gotten there yet. Amanda, how would she contact experts? Through legal mail, through phone calls? She could call them and then have private conversations with them where even if the jail calls were listened to, they couldn't be used. It could be just like, you call your attorney or she talks to her attorney. It could be via Zoom. They also have like advocates or even standby counsel that can help her with things like this. We'll see what happens with standby counsel because, again, I didn't see anything like that about that in the order, and we didn't get to watch the hearing. I really hope we get to watch it eventually. Sarah finally has a kind of gentle attorney who will listen and respect her. Oh, Tammy. Oh, Tammy, you got her. Ashley Harris, hi. Have you seen anything like this before? I have never seen somebody forfeit their right to counsel without them wanting to do so, right? I've seen people waive the right to counsel. I've seen people represent themselves, obviously, multiple times, but this is very, very different. Is there a response from the court on this letter? So no, they had this hearing. So this letter was written on the 25th, but they had a hearing on the 28th. The court didn't get this letter until the 28th. So he had already made his order. They had the hearing. Boone asked questions. I assume he answered those questions. Cashman was allowed to bounce. But we don't know what his response is to this letter. And more importantly, we don't know Sarah Boone's response to granting Cashman's motion to withdraw and for her forfeiting her right to counsel. By the way, I don't think I have the docket up here anymore, do I? I think I may have X'd out of the docket. Yes, I did. The pretrial date is the end of September, basically. And I think October 17th, something like that, mid-October is the trial date. So this trial is happening in like 3 months, allegedly. As an OC resident and taxpayer, Sarah Boone owes me money now. Well, thankfully the court cut it off. Is she legally sane in your opinion? Yes. She is, well, sane. I will say she does not lack capacity to represent herself, right? Not necessarily that she's sane. That's a little different. She's competent. Competent is different than sane. And I think at this point, legally speaking, she is competent. If there are issues that come up with that, the judge can have somebody do a meet with her, have a consultation with her, and give some kind of report on her competence. We saw that happen with Daryl Brooks, but she has not really shown any signs. These letters, again, show that she may be delusional, but she's competent. If she wants to testify and she's representing herself, how does the questioning work? So usually what happens is she would just take the stand and she would give a narrative. Now, if she starts talking about hearsay or goes into something that's inadmissible, the state can still object and say, objection, judge, and the judge can instruct her, you can't say anything else that somebody else said outside of court. Usually when this happens, and this happened in my case where the lawyer / pro se litigant and client took the stand and he did some crazy stuff. We didn't object a ton, only when it really got outlandish. He was mostly trying to garner sympathy with the jury and things that he was saying, and they were having none of it. Talk about lack of social awareness. He was lacking in a major way. But usually they just take the stand. They give a narrative, meaning I woke up that morning, bought a bottle of wine. We shared some. Everything was fine. We had fun. He put himself in the suitcase. I made sure there was enough room. I went upstairs. Next thing I know, I wake up in the morning because I passed out, fell asleep, whatever. She would basically just tell the story like that. Next letter is her complaining about herself. Would that just be poetic? Melanie. It seems like going pro se might be beneficial for the court. With the limited amount of time Sarah Boone needs to scramble after going through so many attorneys, I will just tell you it is never beneficial to the court or the state when somebody goes pro se. I have never seen it get easier when somebody goes pro se than if they just had a public defender or something there. Those are usually much easier. Because we can deal with lawyers. We can deal with legal arguments. We can deal with the normal everyday stuff that is our job. Sometimes it's very hard to deal with a person of Sarah Boone's mindset or Daryl Brooks's mindset. Linda, question, Peter, what are your thoughts on how the prosecution may be thinking at this point? Do you believe they're happy this happened? No. I think they would have been happy if some public defender would have come and represented her, or if Cashman could have stayed on, somebody that knows what they're doing. I think they're confident in their case. It's easier to work with good lawyers a lot of times. I always say that. I'd rather work with a good and honest and legitimate lawyer than either a shyster or somebody that sucks and doesn't even know what they're doing or doesn't know the rules, because then you got to watch everything they do. You got to do their part and your part and explain to the judge why all this stuff is wrong. So no, I do not think they're happy about this. Joanne, so random question. By law, do lawyers have to keep files, not discovery, for a certain amount of time after withdrawing? So not necessarily. There are different things where we write letters to all of our clients and we give them a time period and say, we're going to shred the hard copy if you don't pick it up in 30, 60, 90 days, whatever it is. My dad used to keep files for like 7 years or something, which we used to do stuff like that. We have a digital copy of most of the stuff. We'll scan the important documents to keep them for the most part. We try to put clients on notice, but I'm not aware of anything specifically that says you have to keep them for however many years. We still do keep a lot of the documents for 7 years, and a lot of the digital documents. Obviously, it's a lot easier to store them in the cloud than it once was. Okay, so that is the Sarah Boone update. And you guys realize and understand how quickly this could approach. There is at least a chance it gets continued and doesn't go. But I also think If she does nothing but this for the next 3 months and she's like, I'm screwed, I got to represent myself, maybe there's a better chance of this going than if she had a lawyer on the case who had other cases and other things to deal with and other scheduling issues. So hopefully we are pushing towards trial. I'm hopeful. Let's get justice for the victim in this case. Let's get justice for Sarah Boone if a jury ends up saying she didn't do it and she's not guilty. Due process is due. It's overdue. So thank you everybody for joining me. Make sure you guys hit the thumbs up if you have not, and let me know what you want to hear and what you want to see. New stuff's happening. Baldwin's coming. Valo stuff's happening, but you guys always drive the content on the channel, and I appreciate it so much. And it makes it a lot more enjoyable for the interaction with the questions and the comments when you guys are interested in something. And I'm just here for the ride. So I appreciate you guys. As always, till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a know you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.